Thank you, Mr. Chairman, members of the committee. Bryan Blevins on behalf of the Texas Trial Lawyers Association, and we are opposed to House Bill 969 by Representative King. We do want to thank Representative King. He has been patient with us. He has met with us. He has heard our concerns, and he has continued to work with us in trying to address those concerns. But the bill, as the committee substitute, actually continues to achieve the same goal of the original bill, which was to prevent the jury from consideration of net worth evidence. It does that by establishing a standard that is otherwise not understood or appreciated in Texas law, which is a substantial likelihood on the success on the merits. Now remember that the merits here would be a punitive damage, gross negligence, malice, intentional. So we're talking about the highest standard, the highest level of proof, and we don't know what a substantial likelihood of success on the merits then would look like in that case. Mr. Hull references us to the temporary injunction standard, and I would argue that that's an extraordinary remedy. In fact, in a temporary injunction standard, there hasn't even been a lawsuit filed. No discovery's been taken, no notice. In fact, what you're doing is you're coming in and you're asking the court to stop someone, in which you have to then go forward and prove that the injury that's going to occur is so great that it outweighs the potential injury of stopping. That's an extraordinary remedy. All we're talking about here is asking for some evidence of net worth. This isn't about admissibility. We're not talking about proving our case. We're being asked simply for evidence, which the Supreme Court of Texas has ruled time and time again is relevant, it's probative, and it's informative to the jury. Contrary to what you've heard by Mr. Hull and others, that this evidence is wide-ranging and that defendants are being run ragged by this discovery, that's simply not true. Under Texas law, Texas has a general notice pleading. Under general pleadings, you have to give the other party fair notice. But that's not true in exemplary damages. In exemplary damages, a plaintiff must plead with factual specificity sufficient that if those allegations are true, they would prevail on the merits of that matter. So consequently, we have to plead with specificity. The courts have multiple opinions where net worth evidence has been limited to the current year, been limited to a very specific scope. The discovery of a witness has been specifically limited in terms of deposition testimony. So there are a number of limits that are already in place. But the real concern that I want to point you to is this. So let's step back for a moment and think about a substantial likelihood on the merits. Well, a lawsuit gets filed. The first stage is a 91A motion to dismiss on the pleadings. That's a current and existing rule. Under that pleading, I could have my case in its entirety dismissed, but I still wouldn't have met a substantial likelihood on the merits just to get some evidence. The next stage, a no evidence motion for summary judgment. They're going to actually take away my cause of action because I can't produce a scintilla of evidence. I can meet that standard, but I still can't get evidence of net worth because I'm not at a substantial likelihood. You have a standard motion for summary judgment. Now, each time we're talking about my actual cause of action, and here, as long as I can create a fact question, I can proceed with my case, but under this standard, I cannot get evidence of net worth. The reality is, what judge is going to say that you have a substantial likelihood of getting a clear and convincing evidence finding unanimously of malice until the jury tells them so? And so what happens, and I'll wrap with this, is that the jury will come to the point of reaching its decision, and it will have never been able to see this important evidence of matching the wrongdoer to the wrong.
Mr. Chairman. Mr. Sheets?
Thanks, sir. Sir, you may or may not know the answer to this, but in a typical case where you're pursuing punitive damages, is it a certain type of defendant?
No, actually, the punitive, I very much appreciate that question because I think there's almost a presumption we're talking about a personal injury case where an injured person versus some corporate defendant. But this could involve a commercial litigation dispute over insurance. It can involve two multi-billion-dollar corporations. So punitive, this is affecting the ability of any party. And with respect to that also, Representative Sheets, it also creates a real mechanical problem here because how would a defendant in the case get evidence of net worth of a co-defendant? Do they have to meet my burden? Do they have to prove that I'm going to have a substantial likelihood of success on the merits in order to get net worth evidence to show that they may be worth $5 million, but the company that that's with them as a co-defendant, it's worth $5 billion? It's a significant mechanical problem. I apologize.
No, and then when you're suing, because I think a lot of people think about corporations, and when you're talking about publicly held corporations, I mean, that information is publicly available to you anyways, is it not?
It's publicly available, but not always in an admissible format. That's one of the problems that we run into, and under the bill, they talk about it not being about admissibility. Well, what that really does is set up a dual standard. Again, net worth evidence can be available in a public setting, assuming we can get it in an admissible format, but that means the private companies, though, would have a distinct advantage. Even when there's two defendants, one public, one private, one would have net worth from the get-go, the other one, net worth would never have to be produced either to the plaintiff or to their co-defendant.
What do you use it for during trial?
Depends on whether or not the defendant decides whether or not to bifurcate the case. And that, as you know, is a choice the defendant gets to make. Under current Texas law, either you bifurcate and you prove your negligence and your gross negligence case, and all of the evidence of gross negligence comes in except net worth. That evidence is excluded until the second phase, which is the exemplary damage phase. But that's a decision that the defendant gets to make, and under this standard, if I've never been able to obtain it, I think it effectively means the defendant chooses not to bifurcate.
Mr. Blevins, as you just mentioned, the fact that we allow the defendant to bifurcate, and that's the main difference is that the exemplary damage, the net worth evidence isn't shown to the jury, and that's because that evidence is so prejudicial, right? I mean, that's because we figure, the jury's going to see you're rich, and therefore we're more likely to hold you responsible. I mean, doesn't that kind of go to the heart of Mr. King's bill, that we've already considered this evidence to be so prejudicial and so dynamite that we take special steps with it? I can see why he's concerned enough to want to be very clear with this evidence.
And I do, and I appreciate Representative King's concerns, and we've had several discussions. And the reality is that this legislature has revisited punitive damages and exemplary damages probably 10 times over the last 15 years. For instance, the cap situation, and it was mentioned before that caps have some relevance to this. The reality is that we've had caps on punitive since 1987. It wasn't until 1995, a tort reform session, in which TLR brought substantial tort reform measures to punitive damages and exemplary damages, and within those measures was the factor of net worth. So we've had net worth admissible, relevant, and probative before a jury for over 20 years, while at the same time having caps on damages, on those same punitive damages.
Mr. Clardy?
Thank you, Mr. Chairman and Mr. Blevins. One thing we have to keep in mind that this bill has to do with discovery of evidence.
Yes, sir.
I think historically in Texas we've had very permissive rules of discovery, open discovery, but with certain limitations that have been built in by the legislature and the courts. And, to go back to what Mr. Hull said, it seems to me there's really two things we ought to be focusing on with this bill. One is, as he said, all it takes is to put on the pleading, I want punitive damages, there was gross negligence. And in current law, you're entitled to that evidence. And so we do need to have some process where we can ferret out those weak claims where there's really no basis in fact. And there's nothing to give rise to a claim for gross negligence or reckless or intentional conduct, which you described. And get those out of the way early in the process, just to avoid that whole argument. And I've certainly been on that side of those cases. And we've been helped, I think, as practitioners by the creation of the no evidence summary judgment rule, which fairly early on in the process, you can't do before discovery, but as the discovery process is substantially completed, you can go forward with a no evidence motion and say, there's nothing here, Judge. Nobody was drunk, nobody was, driving in violation of law, et cetera, or in a business context that, there's no evidence to show there was fraud or active concealment, what have you. And so that gives you an avenue to get those cases dismissed by the court if there's nothing there. Conversely, though, it seems like it does make sense that as attorneys develop the case that you need to be able to evaluate the relative strength and weakness of your case, and that includes claims for gross negligence. And part of the calculus of an attorney, I think when you review, and you can speak this better than I can, is that you might have liability and you might have damages, but if you don't have recoverability, it's like going to the casino. If all three cherries don't line up, it's not worth a whole lot. And so the discovery of net worth doesn't apply so much to, I think, as you said, the stereotypical case where you have public companies where you can go get their 10Qs and 10Ks, you can go, you know what they have. It is going to be for smaller entities, which I think the TADC has come up, of which I'm a member. And there are those circumstances where you're defending someone that they literally may have an appearance of having money, but they've had economic distress, and they have evidence they want to show that this is not, there is no pot at the end of this rainbow. Leave this alone. There's nothing here to pursue, which again can be factored into the evaluation of the process both by the defendant and the plaintiff, and perhaps I think oftentimes would lead, if that information's out there, to a quicker resolution and closing of the case. So I mean, I think there are legitimate interests on both sides of the case, and he brought up the bifurcation issue, which I think most defendants do elect to do, but it does create a problem if there's been no discovery of that, and then there is in fact a finding of gross negligence. You've survived all these different stages as a plaintiff. You've said, okay, we've found gross negligence. Now they put on your damage case, and you've got nothing to show. How does that fit?
Well, number one, I agree that every piece of evidence becomes part of your evaluation process. And I have had defendants use effectively their net worth evidence in a case, because keep in mind, we're not talking about gross revenues. We're not talking about a year's profits. We're talking about the asset base of the company in terms of net worth analysis, and many times that's lower than what many people might think it is. But the approach that we favored throughout these discussions, Representative Clardy, has been, let's look at the law as it's developed, and to the extent that there's some uncertainty or there is some moving pieces between the courts, then let's take the best of what the law has already told us. Let's perhaps try to codify that in terms of a definition of net worth. There is behind the little diagram I gave you, there is this summary of key facts, and one of those would be the very fact-specific pleadings. You cannot just put the word gross negligence down on a piece of paper and be entitled to get net worth evidence. You have to plead specific facts that to a reasonable mind would say, yeah, if that's true, they're grossly negligent, they were guilty of malice. And also limited discovery, how many courts have reeled repeatedly as to how we tighten up this evidence. And so our approach that we favored has been, let's look at the current law, let's take Representative King's concerns into that mix and see if we can't tighten that up so that it doesn't become a process that's abusive. And then let's slap a protective order over the top of it so that we maintain confidentiality until such time as it goes to trial.
Right. And if I could just follow up on that, I know it's been my practice on those cases to call it belt and suspenders, but to require a confidentiality order or a protective order when this discovery has been either compelled, which oftentimes I'm somewhat reluctant to provide it, and resist those efforts, and I will, we go through that dance. But again, I like the idea of having a gatekeeper, and that being the trial judge who's been dealing with the parties and marshaling the evidence and through the discovery process. And I do think it does need to be the least intrusive measure and way to do it. And so not make this a fishing expedition, not make discovery a burden and penalty in and of itself to a defendant whose allegations have been made. One question I do want to ask was what Mr. Hull said about the standard that's in the committee substitute.
Yes, sir.
And I think I heard Mike correctly on this. He's quotes from California statutes, other venues, but it's the language substantial likelihood of success on the merits. And almost to me, although I'm an attorney, I'm reading this kind of more in lay terms, that sounds to me like a standard that's actually harder to meet than even clear and convincing. And I think I heard Mr. Hull say, Mike can correct me, that it's below preponderance of the evidence, which that's not the way that reads to me. Because I don't think that your burden of discovery should be as high as the ultimate burden before the trier of fact to make to be successful with the jury, and again being a unanimous verdict. Discovery should be somewhat less than that as the process moves forward. Now that's my personal opinion, but what is as a term of art in cases around the country, has that been defined as something less than preponderance?
Well, for instance, the California statute, in that statute, what it's actually talking about, it's not determined until trial. Just like our fears here, the net worth evidence, if it's produced, is not produced until the actual trial of the case. And again, if you read the bill and the way it talks about how the parties marshal their evidence, this isn't a one-sided event. It's not accept my evidence and if it's true, I get home on this. It's not just my pleadings. It's a contested. We're talking about a mini trial. We're going to actually have a mini trial of the gross negligence if I want to prove a substantial likelihood. And that is so much higher than a no evidence motion for summary judgment on my cause of action or even a standard motion for summary judgment on my cause of action.
But it does need to be a meaningful standard. It does need to be a meaningful review by the gatekeeper. In that respect, I think Mr. King is on to something here, although I hate to admit that in public. But that it does need to be something that says, prove to us that you're going to be able to get past the directed verdict stage. Show us that you've got something, or to get close there. And I'm not sure where that is, and that's where I'm not sure where substantial likelihood falls on that spectrum of no evidence, preponderance of the evidence, all the way up to beyond a reasonable doubt, and somewhere in between is clear and convincing. Where is substantial likelihood as the cases have interpreted it around the country? And that's what I don't know.
We're certainly willing to work with Representative King as we have, and will continue to do so. And fundamentally, we want a system that recognizes that there is a balance of interest to be measured here, that there is a confidentiality, there is a privacy factor, there is genuine interest in not producing the information, but also that there is an equally important, relevant and probative value to that evidence that makes up a part of the case. And we just want to find the balance point. I don't think I should have to be proving my case, showing all my cards, for instance, to a savvy defense lawyer or two or three or however many are on this panel. There are quite a few lawyers. I don't know that I want to be showing my cards, to have to show all of my cards in order just to get net worth evidence. That doesn't seem to be an appropriate burden.
Okay. Thank you, Mr. Blevins.
Mr. Chairman, there are a couple of things I wanted to address because they seem kind of like straw men to me. I mean, the idea of a defendant who wants to show his net worth, to show, look, there's no there, you don't need a bill for that. I can always go to my opponent and go, I haven't got any money. That doesn't require a bill. And to the extent that on the other side, the plaintiff wants to develop evidence for his recoverability calculations, that would be no more relevant in an exemplary damage case than in a case without exemplary damage. You still would like to know how much, but we don't let you. We don't let you go get exemplary. We don't let you get evidence of net worth because it's only relevant to exemplary damages. So I don't see that that's really an issue. It seems to me, and again, I think the heart of Mr. King's bill is, as lawyers, we expect that we can go into any business with a proctoscope when somebody's filed papers, and we get to go in there and start. At one point, I had read every document there was in the airline industry because we had a piece of litigation going, and businesses don't see it that way. These folks who are going about their business trying to create jobs in their community don't see that they should be ripped open and have to give up all the evidence of their net worth and all the other things just because somebody's filed a piece of paper and no one has proven anything against them yet. So I see his purpose in saying, we need to be very careful with this, and we don't just necessarily do open heart surgery on everybody who's had a suit filed against them. I think that the fact that we do have caps makes the net worth of a defendant a whole lot less relevant than it used to be when the sky was the limit. If you're only going to be able to get 2 times the actual damages, it doesn't really matter how much the guy's worth. And so I agree with the purpose of Mr. King's bill. I liked it better as it was filed than as it was negotiated, but I don't get to decide those things. I'm not the author. And that's just kind of where I'm coming from.
And Representative Schofield, we've agreed to disagree in the past. I have a feeling we'll probably continue to do so. But with respect, the law has not worked out that way in terms of discovery. And there is, even in the issue of net worth has been available throughout the period of caps. Caps are nothing new to the concept of the relevance and admissibility and usefulness of net worth. The reality is that net worth is the only evidence. If you look at all the factors that are provided there, the net worth is the only factor that allows a jury to match the wrongdoer to the wrong. The rest of it is about the amount of money to the conduct. Here, it's about making sure that the jury can assess the appropriate penalty for that particular wrongdoer so that we don't put him out of business. So that, in fact, it's enough to deter conduct, but not enough for them to plan business decisions around.
That's always, I enjoy going within. I wondered why you were here, because I didn't have a bill up, so I knew that you couldn't be here to testify against one of mine.
One day, I'm hopeful I'll be able to testify for one.
Any other questions? Okay, thank you very much. Appreciate it.